You are listening to lawwithdenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, torts, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
To this lesson on murder and actus reus and causation. The lesson will explore the meaning of murder, and we'll also look specifically at the actus reus of murder, and we'll look at the legal principle or theory of causation as it relates to murder specifically. By the end of the lesson, I hope that you'll be able to define murder in English law, identify the actus reus of murder, use case law to explain the difference between factual and legal causation, and use case law to explain how the chain of causation can be broken. So those are the aims for the lesson. On the board or on the PowerPoint, I have a list of keywords on the left-hand side, and I have a list of definitions on the right-hand side. You'll notice that the keywords are numbered and the definitions are lettered. Now, the keywords don't match the definitions at present, and I want you to match them. So I have a little task for you. What I want you to do is to pause the video and write down what you think the correct matches are. So for example, you'd write number one. Number one is actually correct, so I've given you that one. Number one, you'd write number one and A, because number one, which is fatal offense, is in fact an offense which involves the death of a person. But number two, I haven't given you, so your task is to find what is number two, what is homicide? Number three, factual causation, I haven't given you either, so you have to find the answer for factual causation. So there you have a list of keywords, and you have a list of definitions which are not matching at the moment, and I want you to stop the video, see if you can match them, and then turn the video back on. You're back! Right, now, I hope that wasn't too difficult, and even if it was difficult, don't worry, because the aim of the lesson is to help you to understand them better. But I thought it would be good for you to have a go, see what you already know, because you'd be surprised how much we know from, other legal studies, or just from being a just as a lay person, we pick up so many keywords, and we do know a lot. We know more than we realize. So with that being said, let me give you the answers. So number one, fatal offense. I gave you this one, so you shouldn't be cheering too much about getting this one right. I told you fatal offense is an offense which involves the death of a person. So you have 1A. Number two is homicide. That's the killing of a human being. So 2E. 3 is factual causation, and that's the principle that the action of the defendant caused harm. So 3F. 4 is the legal causation, and that is the examination of an action to find out if it contributed to harm. So you have 4G. 5 is an intervening event, and that is an event that breaks the chain of causation. Actus Reus, which was 6, is D, and that's the guilty act. Thin skull rule is number 7, and that goes with H, which is take the victim as you find them. And lastly, we have mens rea, which is the guilty mind. Now, murder, and just to say that a lot of these keywords will be explained and delved into in more detail. Mens rea will not be looked at a lot at all, right? I have a separate lesson for that. And but in this lesson, we will look at factual causation, legal causation, intervening event, actus reus, thin skull rule, homicide, and fatal offenses. Fatal offense. Now, we are specifically looking at this fatal offense and this homicide. We are looking at murder. Murder is an example of a fatal offense because, remember, fatal offense is an offense which involves the death of a person. When a murder occurs, somebody's dead. Murder is also an example of an unlawful offense, homicide. What is homicide? The killing of a human being. Why is it unlawful? Because it's not legal, right? And we'll find out in the lesson that sometimes it's legal to kill another person, but murder isn't one of those examples. Murder is an unlawful homicide. It is illegal. Now, examples of fatal offenses are voluntary manslaughter. So in addition to murder, we have voluntary manslaughter. We have involuntary manslaughter, and we have murder, of course, because that's what we're doing here. And we also have corporate manslaughter. Those are just some other examples, but we will continue to focus on murder. And I already explained to you what the difference between unlawful or lawful homicide is, but I will go into it just a little bit again, just to remind you. So homicide is the killing of another person by another person, and homicide can be lawful or unlawful. Lawful homicide means the killing of another person, which is illegal. And we have some examples of that we're going to talk about in a minute. But unlawful homicide means that the killing of this other person is illegal, so it's not allowed by law. Now, I want you to think of, I already gave you some, you already know that murder is an example of an unlawful homicide. But I do want us to switch our brains to lawful homicides. Can anyone think of examples of lawful homicide? Like, when is it okay to kill another living being? When would you get away with it by law? You could, well, it is lawful homicide if you end up killing another person using reasonable force in self-defense. So if you are defending yourself and you end up killing another person, but you can demonstrate to the English courts that when you kill that person, you use reasonable self-defense, that killing of the other being, that homicide, could be deemed to be lawful. If you kill during wartime when the objective is to destroy the enemy, again, that is lawful homicide, but it has to be during wartime and the objective has to be to destroy the enemy. And examples of unlawful homicide, of course, are murder, involuntary manslaughter, and voluntary manslaughter. Killing of another human being, but it is not permitted by law. So what is murder? Because we had other unlawful homicides listed here. But what is murder itself? Because there are differences between all these different unlawful homicides. And if we want to convict someone of murder, we need to understand exactly what it is. And if we want to convict someone of the other offenses, we need to understand what these offenses are. But in this lesson, let's begin to ask ourselves, what exactly is murder? Now, we don't have any act of parliament, we don't have any statute, any legislation which tells us what murder is, which defines murder for us. But what we do have is we have a definition which comes from common law. It is common law that we turn to for our definition of murder. Common law being case law, being the courts. And we always turn to Sir Edward Coke's definition in 1797. Sir Edward Coke was a judge, and he told us the following. Murder is when a man of sound memory and of the age of discretion unlawfully killeth within any country of the realm any reasonable creature in rerum naturana, under the king's peace, with malice aforethought, either express or implied by the law, so as the party wounded or hurt, etc., die of the wound or hurt within a year and a day after. So from this definition, we do get, just trying to get my pen out here, we do get the actus reus of murder, and we also get the mens rea of murder. So remember, actus reus is the guilty act. So when we say that, what we're looking for is, what act does a person need to do in order for them to be guilty of murder? And that act is the unlawful, oh, my pen doesn't work. Okay, it does work. Unlawful killing, right? Within any country of the realm of any reasonable creature in rerum naturana. And I'm going to try to get the pen to stick there. Okay, so we're looking for the unlawful killing within, it's gone again, unlawful killing within any country of the realm of any reasonable creature in rerum naturana. This rerum naturana refers to a living human being. And this is going to become so relevant later on when we look at some of our cases. And under the king's peace. So the killing needs to take place under the king's peace. Again, remember, what we're looking at is that there is no war going on. Because remember, I said it can be lawful. It is lawful to kill when we are at war if your objective is to kill the enemy. So if you have killed someone unlawfully, and it's a living being, and we're at peace, this is murder. So this is your actus reus of murder. This is the act, right? I'll just mention now as well that for murder, it is not only an act that constitutes the actus reus, but omission. And omission can also constitute the actus reus of murder. And we'll look at a case which helps us to understand that later on in the class. Now, additionally, we need to understand our mens rea of murder. This class is not focused on the mens rea of murder, but I do want to point it out here, right? Just point it out. So the mens rea starts here. Let me get the blue pen for that one. And that is with malice aforethought, either express or implied by the law. Okay? Either express or implied by the law. Malice aforethought. We're going to explore what these mean in more detail later on in the class. But in Sir Edward Coke's definition from 1797, as you can see, we do get a definition of murder. And then we have other case law, which comes up later on, which helps us to understand exactly what murder is, what we're looking for when we have a defendant who is accused of murder, and whether or not that defendant will be found guilty or not. So let's look at some of that now. To put the pen away, I think. Done. So you click done, say your pen's done. You put your pen away, and then you move on. Now, I already said what the actus reus is. So the actus reus is the unlawful killing of another living being. The mens rea is the intention. So we saw it as malice aforethought, either expressed or implied by law. For law students, you don't need to, well, even if you state what Sir Edward Coke says, you need to understand that what it means is that mens rea is the intention to kill or the intention to cause grievous bodily harm. And that was confirmed in Vickers 1957. Now, let's look a bit more at this actus reus. As I said earlier, the actus reus is the unlawful killing of the living being, and it can occur as a result of the defendant's actions or their omission. So in most cases, it's pretty straightforward to identify the actus reus of murder. If the defendant shoots the victim and the victim dies, that is murder by an action. The action in question was a shooting. If the defendant stabs the victim and the victim dies, that is murder by an action, which is stabbing. Now, how about when you have a situation in which someone takes on a responsibility and they now have a legal responsibility to care for a victim and they fail to care for that victim and it leads to the death of the victim? This is an example of murder by omission. So we have this case of Gibson and Proctor, in which a mother and father, I think one was a step parent, but nevertheless, they were legally responsible for a child in question, and the child had not been looked after, the child had not been fed, and the child ended up dying. And the court decided that they were in fact guilty of murder, and they were guilty of murder not because they performed an act which led to the death, but because they didn't perform acts which could have prevented the death of the child. So we're talking about murder by omission in Gibson and Proctor. So important to note that actus reus, even though in most textbooks and in most classes we start off by saying actus reus is the guilty act, sometimes this definition is not adequate. And because as with murder and with some other offenses, actus reus is not only a guilty act, it can occur as a result of an omission. Now, our next question is we're still looking at the actus reus. And remember in the definition given by Edward Coke, we had that part about the killing, unlawful killing of I don't remember what his exact words before, but he mentioned rerum naturana. Now that refers to a person being a living, breathing human being, right? So that's what he means. So if you're going to commit murder, if you're going to be convicted of committing murder, it needs to be demonstrated that you killed a human being, a living, breathing human being. Now, this seems pretty straightforward to us if we're thinking of straightforward cases in which someone shoots a walking, living, breathing person. There's no dispute about whether this being is living and breathing. But in some cases, and in cases related to babies living in the womb of their mothers, this can become a question. This question is posed, and it has been posed before, and unfortunately continues to come up because of the court's perspective on it, the law's perspective. So if we turn to this question that the court has been asked before, and the question is an unborn baby in the womb a living, breathing human being? In R and Polton and R and Enoch, they said that a baby is not a living, breathing human being until it is fully expelled from the womb to have they're allowing it therefore to have an existence independent of the mother, right? So they're saying if the baby is in the womb, the baby does not have an existence independent of the mother. And if you want to be called, if for us to recognize the baby as a living, breathing human being, the baby needs to be fully expelled from the womb. Now, what does that mean and what implications does it have for other cases? This is the implication it has for other cases and did have. Let's look at Attorney General's reference number 3 of 1994-1997, right? We're going to put it into context and see how the rule from Enoch and Polton affected this case, the decision in this case. So we have a mother who is pregnant, as you can see in the photo. She's pregnant. And we have a boyfriend with a knife. Never a good ending to come about. So the boyfriend is the defendant. And what he did was he stabbed his girlfriend while she was pregnant. And I have a typo there. I must correct that. So the stabbing penetrated the baby. I'm going to try and write a D here. Oh no, did I do D? Yeah. The stabbing penetrated the baby. He's gone as well, right? So he stabbed his pregnant girlfriend, and the knife went obviously into her belly, but it also went into the baby, right? So he managed to stab the baby, who is still living in the womb, not fully expelled. The baby was born prematurely and died 4 months later. So the baby ended up dying before being born before he or she, I don't know if it was a boy or girl, before they were due to be born, and the baby ended up dying 4 months later. Now, evidence showed that it was a stab wound which caused the baby's death. And the defendant was charged with murder. Now, pay attention to your language. When we say charge, it doesn't mean that he's been to court yet. We're talking about what he was taken to court for, right? So he's taken to court for this offense of murder. He's charged with murder and he goes into court. What do we think the court said about the defendant? Do you think it was decided that the defendant was guilty of murder? Remember the definition of murder. Remember, we're looking for the unlawful killing of a living human being, living, breathing human being. And the mens rea is malice aforethought. Now, let's pay attention to the actus reus, which is the killing of a living, breathing human being. Remember Enoch and Polton. Remember that the court said in order for a baby to be recognized as a living, breathing human being, that baby needs to be fully expelled from the womb. If you remember that, you should be able to guess what the court said in response to the defendant's charge of murder. Let's put the pens away. Okay. And the court said this. So first at trial, so he goes to trial, he's charged, he goes to trial, and he was acquitted. So he was not found guilty. And he was acquitted because the judge said the case was not homicide. Remember, The homicide, at the beginning of the lesson, we confirmed that homicide is the killing of another living being, another person, another human being. So the court's saying the baby is not, the baby was not a human being. It wasn't a living, breathing human being. So therefore, the court was basically following Enoch and Polton. But following the trial, there was an appeal, and that appeal went to, obviously, the Court of Appeal Criminal Division. Well, yeah, not obviously, but the appeal went to the Court of Appeal Criminal Division. And in the Court of Appeal, they said the trial judge was wrong. They said, you're wrong. And they said, the Court of Appeal said a murder conviction was possible. And they thought it was possible through use of transferred malice. Now, I'm aware that some people may not be clear on what transferred malice is, and I did not put it in the key terms and definitions earlier in the class. So what I'm going to do is jump to the next PowerPoint, and we're going to discuss what transferred malice is, and then come back to this, right? So transferred malice means that the intention to cause harm in an offense can be transferred from one person to another person. So let's put that, let me try and explain that in more detail to help you understand. What it means is that if A has the intention to shoot and kill B, so let's give A a name. We're going to call A Aaron, and he has to shoot and kill B Brandon, right? And he misses and he kills Claire. His intention, A's intention, which is Aaron, is now transferred to the victim C, even though he intended to kill B, Brandon. So if we go back to our story with the pregnant lady, her baby, and the defendant, who is the boyfriend, who is A? A is the defendant, so the boyfriend. The boyfriend has the intention to shoot and kill B, the girlfriend. That's what the Court of Appeal was saying. The Court of Appeal was saying, if we look at it this way, we can find a murder conviction. And they're saying, if we look at it this way and we say A is the boyfriend, right? The boyfriend had the intention to shoot and kill B, the girlfriend, which, well, in that case, it was a stabbing. So A had the intention to stab the girlfriend B, and to kill the girlfriend B, but he didn't manage to kill her. Instead, he killed the baby, C. We're going to the Court of Appeal say, transfer that intention from girlfriend to baby. And we're going to say, you had the intention, you had the mens rea to kill the girlfriend, but you didn't manage to kill the girlfriend. You managed to kill the baby. So therefore, we see you liable for the killing of the baby, right? So they're saying, they didn't say we see you liable, but they're saying it's possible if we use this method, if we use this method of transferred malice, this principle, we will be able to find that a murder conviction is possible. So let's go back. At trial, the defendant was acquitted. The judge said there wasn't any homicide. This is not a homicide case. And why are they saying that? Because they don't recognize the baby as a living, breathing human being. They know that the Actus Reus of murder requires the killing of a living, breathing human being. And they know that cases such as Polton and Enoch have told us that in order for a baby to be recognized as a living, breathing human being, that baby needs to be fully expelled from the womb. So they say you can't kill a baby that is not fully expelled from the womb for the purposes of the Actus Reus of murder in English law. Then an appeal goes to the Court of Appeal, and the Court of Appeal says, actually, you're wrong. I have ring, but it should be wrong, right? They said, actually, you're wrong. The court said, they said, a murder conviction is possible. Use the principle of transferred malice, and you will see that a murder principle is possible. Use the principle of transferring that intention to kill the mother to the baby, and then you are able, it is possible to convict this man of killing the baby. But a further appeal was made, and the House of Lords said it was not possible for a charge of murder. So the Court of Appeal said it's possible, and the House of Lords said it's not possible. So the Court of Appeal is drawing us back now, because they said intention could only transferred from one person to another. So we're back to this issue of the baby in the womb is not a living, breathing human being, and the baby is not a living human being because the baby is not fully expelled from the womb. But the House of Lords did tell us that manslaughter was possible. So it's not that he would get, if somebody does this or when people do this, they get away with it, but it's just that it is not sufficient for a murder conviction, but manslaughter was possible at most, according to the House of Lords. Now there are some other interesting cases and issues related to Actus Reus and what constitutes a living, breathing human being, but we're not going to go through them in this lesson. But I wanted to share these cases and explore them a little bit with you to give you an insight into how the court deals with these issues. Now we're going to move on to this question of causation. Now, causation, remember causation was one of our key words at the beginning of the lesson. Causation is the principle that the harm caused was caused by the defendant. And in order for someone to be found guilty of murder, it needs to be shown that the accused person, their conduct or their action or their omission caused the victim's death. Otherwise, you can't convict someone of murder. You have to be able to demonstrate that it's what they did which led to the death in question. The jury must be satisfied that there is factual causation and legal causation. And we will explore what factual causation and legal causation are a little bit later. The courts or the jury must also be clear or sure that there is no breaking of the chain of causation. And we'll see how the breaking of the chain of causation can occur later on. But let's look at factual causation. So when we're looking at factual causation, we're using the but-for test. So if you've done other areas of law, you're familiar with the but-for test. And what we can ask ourselves is, but for the defendant's action or omission, would the death have occurred if we're looking at murder? And if our answer is yes, then factual causation is present. So basically, if it wasn't for your action, would this person have died? If it's yes, then factual causation is present because your action caused the death. Some of my students find it easier to apply the but-for test by doing this. They say, would the result have occurred regardless of the defendant's actions or omission? If the answer is yes, they say no factual causation is present. Now, a case that helps us understand factual causation is the case in question here. Now, I do have a photo. I'm trying to move I can move myself. Nice. So the photo is here. And the photo is of the defendant, in this case, Aaron White. Interesting case, interesting and slightly disturbing. So can you see the defendant has something in his hand? He has poison. Why does he have poison? Because he had the intention to kill his mother and inherit her money. And he had the intention to use the poison, which he has in his hand at present, to kill his mother. He put the poison in a drink, and the mother drank the poison and she died. But medical evidence found that she didn't die from the poison. What she died from was a heart attack. And apparently, the heart attack was not related to the poison that he had put in her drink. So what do you think the court said? Was he convicted for murder? He was not, because he had not put enough poison in the drink to cause her death. So he was instead convicted of attempted murder. Why is that? Because it wasn't demonstratable that his actions of putting the poison in the drink caused her death. So factual causation wasn't demonstrated. And from there we get this legal principle. Go back, please, and move photo. moving my photo. Okay. Yeah, we get this legal principle that causation must be proved in a murder case. Must be proved. And in R and White, it wasn't proved. So that's factual causation. But remember I said that the jury, the court needs to be convinced that not only factual causation is present, but that legal causation is present. And legal causation really becomes an issue when we have cases with more than one contributing act to the consequence. And what the court is usually looking for is demonstration that the act in question, meaning the act that we're accusing the defendant of doing, or that we can see that the defendant did, is more than minimally contributable to the death, or rather, more than minimally contributed to the death of the victim. And let me try and put that into context a little bit through using a case. We're going to look at the case of R and Cato. And it is not, the defendant was charged with a friend's manslaughter, not murder. But we are still using the case because the principle of legal causation was discussed, and it is relevant, right, to murder. It could be used with a murder case. So 2 drug addicts had spent the night injecting each other with a mixture of heroin and water. The morning after, both were ill, and one of them passed away. So one of them passed away. Now the other one was charged with his friend's manslaughter. And this person that was charged with his friend's manslaughter argued that the heroin was not the only cause of his friend's death. Now remember I said sometimes there's more than one contributing factor to the victim's death. And with legal causation, we're really exploring what was the main, or what level of contribution, or what percentage, not specifically in percent, but how much contribution did the defendant's actions make to the victim's death. And the defendant in this case, R and Cato, was telling the court, look, my action of injecting my friend with heroin was not the only cause of his death. So why am I being accused of manslaughter? And the Court of Appeal said, look, the heroin did not have to be the only cause of death. So they made that clear. They said, look, it doesn't have to be the only cause. What we're looking for, the Court of Appeal said, was whether or not the heroin was more than a minimal cause of the death, and that it accelerated the moment of the victim's death. And they said, look, in this case, the heroin was more than a minimal cause of the death, and it did accelerate the moment of the victim's death. So we can see that legal causation was present. So usually the court is looking to determine whether or not the defendant's actions were more than a minimal cause of the death, or if it's one action, was more than a minimal cause of the death. And in this case, they said it also accelerated the moment of the victim's death. Hence, legal causation was present. So remember, you need to demonstrate factual causation and legal causation. If the defendant is arguing that legal causation isn't present, then it is up to the jury really needs to be convinced that it is present before they can convict a person of murder, looking for factual and legal causation. Another thing that may come up is that the defendant may argue that there has been an intervening event, which means they're not to be blamed for the consequences. I'm just trying to move my face around. Let me move my face there. Okay. So another thing that can happen in court is the defendant can say, look, there has been an intervening event. There has been a Novus Actus Interveniens, meaning there has been an event which has broken the chain of causation. So they might be able to say, look, okay, right, my action caused the harm or caused the death. But if you look at it, you'll see that between my action and the result, the death, something else happened. And that something else in the middle, that was an intervening event which broke the chain of causation. So, hey, you can't say I'm guilty of murder. But our next question could be, what types of actions can a defendant reasonably bring in front of the court and say that these actions have broken the chain of causation? And one of those is actions of a third party. So the defendant can say, I did this, and then this, and they died, but look what they did in between that. Not my fault. Or the defendant can say, I did this, and actually I got that wrong, didn't I? So let's go back. So the defendant can say that the actions of a third party. So I did this, and the victim is dead. But after I did this, somebody else, a third party, did something else, and I think when they did that, that meant that it wasn't me that caused the death of this victim. I shouldn't be at fault for this. Or they can say, I did this to the victim, and the victim is dead. But look what the victim did to themselves in between that. So how is it that I am guilty of murder? So let's look at some of those cases. Let's see exactly how this works. Cases that you may want to explore further are Paget, 1983, Jordon, 1956, which we'll discuss in this class. And I didn't include discussion on Kennedy from 2008, but we have some other cases that we can discuss, and we will discuss. Let's start off by Jordon, 1958. Oh no, we should have Jordon, 1956. I'm going to change that here. So go back here. Red pen, and we're going to change to 6. It's a 6, guys. It's a 6. It looks kind of like a 6. So Jordon, 1956. In this case, the victim was stabbed, and he died 8 days later. At trial, the defendant was convicted of murder, but he appealed. And why did he appeal? He said, he wanted to bring forward some new evidence on his appeal, and the evidence showed that it was poor medical treatment received after the stabbing which caused the death. So he said, look, I can't be guilty of murder. You convicted me of murder at trial, but I need to show you this. After I stabbed this person, the victim, I know he died 8 days later, so I know it appears that there is causation here, that my action causes death. But let us look at what happened in between my action and his death. And what happened in between was he received poor medical treatment. After I stabbed him, he received poor medical treatment. And in fact, the court, the medical professions shouldn't have given him that treatment. It was extremely poor because he was known to be allergic to the treatment to the medicine they gave him. So why am I guilty? Why was I found guilty of murder? Look at this new evidence. It has broken the chain of causation. It's a new event. And the court agreed. The court said this poor treatment did in fact break the chain of causation. So his conviction was quashed. Put my pen away. The court also said the actions of the medical staff constituted an independent intervening act, right? It's like this is a whole new thing on its own. Look what these guys have done, right? And they confirmed that a new intervening act can break the chain of causation. Now, it doesn't mean that a new intervening act will always break the chain of causation, but what the court was telling us was that it can break the chain of causation. And we'll see how they responded to similar arguments by defendants, because we will see that it was very difficult. It has been very difficult to prove that medical evidence can break the chain of causation. Even though they told us in Jordon that it can, we saw that in Smith afterwards, 1959, and Cheshire, 1991, it was not possible to demonstrate that the chain of causation was broken when medical evidence was used to argue this. What do I mean? In Cheshire, 1991, a victim was shot in the stomach and thigh. A tube was inserted in his throat while he was in hospital. Not this throat. In his throat while he was in hospital. And the tube was inserted to help him breathe more easily. But the treatment led to complications and the victim died. The doctors did not, move in my face, notice the complications. Now, although the stab wounds inflicted by Cheshire at the time of the victim's death, so what I should have said was the stab wounds inflicted by Cheshire at the time of the victim's death were not life-threatening. So this is important. They weren't life-threatening. He was still held responsible for the victim's death. So you can see the court was reluctant, and clearly wasn't going to do it. They were reluctant to break the chain of causation, even though when he Cheshire stabbed the victim, it was shown that they weren't life-threatening, the wounds. The court said the chain of causation was not broken. So those are cases involving a third party, somebody else who's done something in between from the time of the defendant's actions to the death. That's one example, one way in which the chain of causation can be broken. But remember I said there was another way. The other way is when the victim has done something after the defendant's actions. The victim, it can be argued, has done something which has broken the chain of causation, which then obviously has arguably released the defendant from fault. Let's look at one of those cases. One of those cases is R and Blaue, 1975. Now, the defendant stabbed a girl, right? And he was nasty, did a lot of other things, but he stabbed a girl. And she was admitted to hospital, and she was informed that a blood transfusion could save her life. So he stabbed her. She's in hospital because of the stab. And she was told, look, if you get this blood transfusion, this could save your life. But she refused to have the blood transfusion, and she refused because of religious reasons. Unfortunately, a few hours later, the girl dies. And then the defendant argues, hey, not my fault, mate. The chain of causation, he said, was broken. Because he said, remember, I've stabbed her, and then in between that and the death, what happened? She said she wasn't going to take the blood transfusion. So he's arguing that her action, her refusal to take the blood transfusion has in fact removed his fault, that the chain of causation has been broken. But the court was quick to respond by saying, no, the chain of causation is not broken here. And the court argued it's not broken because we are applying what we call the thin skull rule, and you need to take the victim as you found her. You cannot argue that, bearing in mind that when you found the victim, she had these religious beliefs. That's not that is inexcusable. And that is because the court is reluctant to break the chain of causation in most cases. Reluctant to break it when it's a third party, and that third party is doctors or medical professions. And in this case, they were reluctant to do so when the defendant argued that it was the victim's fault because she had refused to have treatment. So that's it, because our aims were to look at the definition of murder. Our aims were to look at the Actus Reus of murder, which we've done, and also to look at causation, factual and legal causation, and the intervening event, right? Intervening event, or Novus Actus Interveniens. So we've looked at that, and we've looked at some cases which hopefully help you to understand all those different principles. I'm going to set you a little task, and the task is to decide if you think the Actus Reus of murder is present in the following case. The facts are as follows. Arnold and Bert are steeplejacks. Steeplejacks, you see the photo with the two steeplejacks? Right. So apparently these people fix chimneys. I did not know what steeplejacks were until very recently. Let's leave it at that. And so they're high up on a factory chimney, and Bert pulls out a gun. So Bert's pretty bad, pulls out a gun, and he points it at Arnold, but Arnold's pretty bad, because why does Bert pull out a gun? Bert pulls out a gun at Arnold because Bert says Arnold has been having an affair with his wife. And you know what Bert says? Bert says, I'm going to kill you, mate. Arnold lounges at Bert to knock the gun from his hand, and in doing so, causes Bert to fall backwards off the scaffolding. You know what scaffolding is? So it's the thing holding them up. I hope these guys are wearing scaffolding. No, scaffolding is not the thing holding them up. No. Scaffold is the thing on the building. All right, okay. Anyway, so Bert falls backwards off the scaffolding and he dies, right? And he dies. The question now is, has Arnold committed murder? Is the actus reus of murder present? And that's the question I am going.
You've been listening to lawwithdenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teachers sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.